everyone, welcome to the next instalment in Jones Chase's A to Z of Employment Law. This short video is on the letter G and I will be discussing garden leave. So what is garden leave? Garden leave can be used either when an employee is resigned or when the employer gives notice of dismissal, and when the employer wants the employee to stop performing their duties immediately but wishes to retain them for the notice period, often requiring them to stay at home. This enforced period away from work is referred to as garden leave or sometimes gardening leave. Historically, the term comes from the idea that during this period, an employee is free to spend time pursuing other hobbies. Garden leave can usually only be enforced once the employee has resigned with notice or been dismissed with notice, and thus it differs from suspension. So why is garden leave used? Generally speaking, garden leave is used by employers to keep departing employees out of the competitive market for a period of time, and in doing so protecting their business interests. Therefore, more often than not, garden leave is used in relation to senior employees who may have access to sensitive information, technical knowledge, or valuable customer contacts, so as to protect the company's goodwill. This is because during garden leave, an employee is still under contract and is therefore bound by all contractual duties, including the duties of confidentiality, good faith, and fidelity. Garden leave may also be used where an employer wishes to allow the employee's successor to take on the role without the previous employee interfering. Whilst on garden leave, an employee must remain available to work, predominantly so that they can answer any other questions or assist with a handover. It is worth noting that garden leave is generally easier to enforce than post-termination restrictions, so it can provide an alternative means of ensuring effective protection of legitimate business interests, particularly in light of the government's plan, announced earlier this year, to limit the length of non-compete clauses to a maximum of 3 months. So, can the employee be placed on garden leave? Importantly, there is no automatic right to place an employee on garden leave. Simply requiring an employee to remain away from the office during a period of notice in the absence of an express garden leave clause may lead to the employee arguing that the employment contract has been breached. Therefore, if an employer wants to be able to put an employee on garden leave, it is important that there is a contractual provision in place to expressly permit this. A garden leave clause should be clear as to the terms of the leave and be drafted to bolster any related restrictive covenants. However, the lack of a garden leave clause is not always fatal. In some circumstances, the employee may agree with the company that they will go on garden leave. In cases where such agreement is not reached, it is still possible that the employer may still be able to enforce garden leave, as employees do not have a general implied right to work, only an implied right to be paid. For example, if an employer has strong evidence that a departing employee intends to join a competitor or intends to harm the employer's business, garden leave may still be enforceable even without a clause in the contract. So what is the effect of garden leave on the contract of employment? As previously stated, the employment contract continues during any period of garden leave. This means that an employer must continue to pay salary at the normal time, provide all other contractual benefits, and allow the employee to exercise their normal holiday entitlement and calculate their holiday in the usual way. The employee must also continue to abide by all of their contractual obligations during the entire garden leave period, except, in most cases, the obligation to carry out work for the employer. A well-drafted and specific garden clause may provide for alternative duties to be carried out during garden leave. For example, an employee may be able to carry out a role that is away from clients and confidential information. So what is the difference between garden leave and a payment in lieu of notice? Garden leave differs from a payment in lieu of notice, often referred to as pylon. When a pylon is made, the employee's contract is terminated immediately and they are paid the basic salary that they would have received during the notice period. The employee will also be paid their accrued but untaken holiday up to the termination date. The employee is then able to start work for another employee immediately, subject to any post-termination restrictions. However, when an employee is placed on garden leave, their contract continues until the end of the notice period. They are paid their normal remuneration plus any benefits, and their holiday entitlement continues to accrue during this period. They are still employed by the company and are not allowed to carry out any work for another employer during this time. Can an employee request to be put on garden leave? The short answer to this question is yes. However, the right to be placed on garden leave is at the employer's discretion and subject to the employment contract, company policy, or custom and practice. A request to be placed on garden leave may happen in cases where the employment relationship is broken down entirely and it would be difficult for the employee to complete their job duties. It is for the employer to assess whether garden leave is appropriate in the circumstances. Possibly the most important thing to remember is that there is no automatic right to place an employee on garden leave, and ideally there needs to be a garden leave clause in the employment contract. This video contains general guidance on garden leave and practical considerations for both employees and employers. This is not intended to be legal advice. If you would like more specific advice on any aspect of employment law, please do not hesitate to get in touch with the team. Thank you.